When the judge says to the attorneys, counselors, go pick a jury, do you know how risky it is for one of the attorneys to say, excuse me, judge, I'm not ready to go to trial? You want to know what happens then? Come join me for a moment as I show you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. In all likelihood, the judge will want to know during a pretrial conference whether or not the case can be settled. And if it cannot be settled, the judge will likely tell the attorneys, listen, when you come back next time, if the case can't be settled, you're going to pick a jury. So now the attorneys come back the next time. They tell the judge, I'm sorry, we can't resolve the case. The insurance company refuses to pay. So now the judge has no choice but to send them to trial. What does he do? Counselors, go pick a jury right now. And now the defense attorney pipes up and says, excuse me, judge, I need to get an adjournment because I'm not ready to try this case. You know what happens then? A number of things. Number one, the judge is going to be furious. Number two, he'll probably start yelling at the defense attorney. Number three, he'll probably wonder why he's not ready for trial when he specifically told him at the last conference that if he couldn't settle the case, to be ready to pick a jury. And now the attorney's going to have to come up with some excuse about why, some realistic excuse about why he can't go forward with the case. Now that's a significant problem for the defense attorney. The judge can still send him out to pick a jury. It's a very interesting strong-arm tactic that the judge has available to him in an attempt to try and get them to settle the case, to force them to go out to trial knowing full well that he's just told them he's not ready to try the case. Now the attorney has no choice but to go with the other attorney and to go pick a jury. But if he knows he can't go forward with the trial, he has only one option, actually two options. He can call the insurance company and try and settle the case, or he can beg and plead with the judge to please get additional time for him to come back. He might say, listen, judge, my expert's not available, or the following witnesses are not available, and therefore I can't go forward today. That's why I'm not ready. Or I've had some family emergency and now I need an extra week or two. There may be a good reason why the attorney's actually not ready. But in all likelihood, the judge is going to force his hand, force him to go pick a jury, and now he's got very little choice. He's got to make that phone call to the insurance company who now tells him, listen, our experts aren't available, the judge is forcing me to go to trial, I need to settle this case. Sometimes it'll work, sometimes it won't. So why do I share this quick information with you? I share it with you because I want you to see what goes on behind the scenes in these civil lawsuits involving accident matters and medical malpractice matters and even wrongful death matters. You know, I realize you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you're still deciding whether or not to go forward with a case and you've got questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.